Okay, friends, looks like it's 9 a.m. in BC and 12 p.m. in Ontario and all different times everywhere else in Canada. So welcome, good morning, good afternoon, and thanks for joining us. I trust that you can all see us and hear us okay. And please note that this press conference is going to be recorded. My name is Pam Palmater, and I'm a member of Eel River Bar First Nation, and that's part of the larger Mi'kmaq Nation from northern New Brunswick. And I'll be moderating this event. We have 4 speakers, and they'll give very brief remarks before we turn it over to the media for questions. And I'll be moderating the question session as well as taking us through the speakers. But first, I'm going to start with a little bit of background so that everyone knows what it is we're talking about, because not everyone's familiar with EMRIP. But on May 7th, the United Nations Expert Mechanism on the Rights of Indigenous Peoples, or EMRIP, issued technical advice to Canada regarding its implementation on the United Nations Declaration on the Rights of Indigenous Peoples and specific advice in relation to Bill S2, an act to amend the Indian Act, new registration entitlements. And we know that's been in the media a lot. So it called on Canada to end the ongoing sex and race-based discrimination in the Indian Act's Indian registration or status provisions, which includes removing the second generation cutoff. For those who don't know, the second generation cutoff rule provides that after 2 generations of a First Nations person having children with a non-First Nations person, the child will not be registered as an Indian under the Indian Act. Not only does that end the family line right there, but we know from Canada's own demographic statistics that this will result in the legislative extinction of First Nations over time. EMRIP was concerned that the ongoing discrimination and the second generation cutoff forcibly assimilates First Nations, which directly violates Article 8 of UNDRIP, which guarantees the right of Indigenous peoples to not be forcibly assimilated. It also violates a large number of other provisions, but this is the primary one. And it's important to mention at this point that Canada enacted C-15, an act respecting UNDRIP, to confirm that UNDRIP has application in Canadian law. So this shouldn't be an issue at this point. But in terms of a background on the expert mechanism on the rights of Indigenous peoples, it was established in 2007 by the United Nations Human Rights Council to assist member states like Canada by they propose concrete actions that states, Indigenous peoples, civil society, human rights organizations, and many others can actually do to implement UNDRIP. And it does this by providing technical advice upon request by either the member state and or Indigenous peoples. And this specific technical advice that we're going to be talking about today was provided in response to a request by Jeremy Matson. It was also supported by NDP MPs Leah Gazan and Jenny Kwan. And Jeremy's going to be one of our speakers today. So thanks to Jeremy for doing the request. And for those of you who need a little background, Bill S2 was introduced in response to the Nicholas decision in 2025, and that related to discrimination against the descendants of a parent, a grandparent, a great-grandparent who had been enfranchised. So that means that the descendants either had lesser or no Indian status. And Canada actually conceded in that case that this amounted to discrimination on the basis of race or ethnic origin, and that the lack of Indian status treats them as less Indian and negatively impacts their sense of identity and belonging. Yet, the legislation they introduced, Bill S2, purported to remove only the discrimination found in Nicholas, instead of remedying all of the discrimination, including the sex and race-based discrimination that disproportionately impacts First Nations women and, in the end, will ultimately impact the Nicholas plaintiffs. After hearing First Nations leaders, their representative organizations, First Nations women and youth, as well as human rights legal experts, and the Nicholas plaintiffs, the Senate amended Bill S2 to remove the second generation cutoff in a historic unanimous vote. Yet the Minister of Indigenous Services Canada has said the department will not accept these changes and that they have to engage in further consultations. This is despite the fact that there is near unanimous consensus from First Nations across the country, all the witnesses at the Senate and INAN committees, and 40 years of consultations, engagements, and collaborations on Indian status, which have all said the same thing. Get rid of discrimination in Indian status, including getting rid of the second generation cutoff. It's also important to note here that earlier this year, the United Nations Human Rights Council called on Canada. They also called on Canada to get rid of the discrimination, including the second generation cutoff rule, and pass Bill S2 as it had been amended by the Senate. So at this point, Canada is not upholding its duty to consult, but is actually ignoring the voices of First Nation leaders and women to delay justice for our kids. And with all of that said, in terms of background, I want to turn it right over to the four speakers. And I'd like to call first on Chief Marilyn Slett. She is the elected councillor of the Heiltsuk, and she is also the Secretary Treasurer for the Union of BC Indian Chiefs. Go ahead, Chief.
Heiltsuk, thank you. Good morning. My name is Marilyn Slett, and my ancestral name is Galajit, and I'm the elected Chief Councillor of the Heiltsuk Nation and the Secretary Treasurer of the Union of BC Indian Chiefs. UBCIC has been advocating for the removal of the second generation cutoff since Canada introduced it in 1985, working alongside First Nations women and leading plaintiffs who are here today. We welcome the technical advice issued by the United Nations Expert Mechanism on the Rights of Indigenous Peoples, calling on Canada to end the ongoing sex and race-based discrimination in the Indian Act, including the second generation cutoff. This advice is timely, as the Standing Committee on Indigenous and Northern Affairs reviews Bill S2 as we speak. After 150 years under the Indian Act and the Government of Canada, they have the opportunity to eliminate the second generation cutoff once and for all. UBCIC joins First Nations across the country, as well as numerous UN human rights bodies, parliamentary committees, and witnesses who are calling on the Government of Canada to end discrimination in the Indian Act and to pass Bill S2 as amended by the Senate committee without delay. The international human rights community, including EMRIP, the UN Human Rights Committee, the Committee on the Elimination of Discrimination Against Women, the Inter-American Commission on Human Rights, and the Special Rapporteur on Violence Against Women have left no doubt that Canada continues to violate the rights of Indigenous women and girls. The National Inquiry has also identified sex discrimination in the Indian Act as a root cause of violence against First Nations women, girls, and gender-diverse people. The combined impacts of denial of rights and the crisis of gender-based violence are devastating, to say the least. Under the discriminatory provisions of the Indian Act, First Nations women in Canada are forcibly dislocated from our lands, communities, and families, disrupting our culture, identity, and governance. They have stripped First Nations women of our rights for marrying non-status partners, caused intergenerational harm, and increased vulnerability to violence and the MMIWG crisis. UBCIC and many others have been consulted for decades, and our position is clear and supported by resolutions. Canada cannot weaponize consultation or hide behind it while shirking its duties, under the Charter. It is not appropriate to delay further and consult when human rights are being violated. As a Heiltsuk woman, a grandmother, a leader, I want our children to be safe, to marry who they choose, to have their children legally recognized. It is not an exaggeration to say that our survival as people depends on Canada's compliance with these recommendations. After 150 years of forced assimilation and denial of rights, we stand united and call on Canada in the strongest terms to pass Bill S2 as amended. Gaiaksika for your time here today.
Thank you so much, Chief. And we appreciate your support, both at the Union of BC Indian Chiefs and your First Nation, and also as part of the Indian Act Sex Discrimination Working Group, of which most, if not all of us, are a part. So thank you so much. I'd like to now call on our next speaker, who is the grandmother to tens of thousands of people all over Canada, Sharon McIvor. She's a member of the Lower Nicola Indian Band, the lead plaintiff in McIvor v. Canada, and of course, the successful petitioner of her case at the UN Human Rights Council. Go ahead, Sharon.
Thank you, Pam, and of course, thank you to the news outlets that are here today to hear our story. My name is Sharon McIvor. I'm in Laketmuk from South Central British Columbia. The Indian Act legislation has, on its first passing, removed all of the rights that we as Indigenous people have. The definition of person in the Indian Act for a long time, including the time that I was born, was a person is anyone other than an Indian. So they not only took away my Indigenous rights, they took away the right for me to be seen as a person. I've been, addressing this, fighting this to end the discrimination and other things in the Indian Act for over 60 years now. 60 years of rallies, hearing court cases, appearing before the Senate committees, the House of Commons committees, lots and lots of media, and over that time, I've worked with, I think I'm losing count now, with over 18 different ministers of Indian Affairs on this issue. And promises from each of them, because they've always acknowledged its discrimination, promises that if we'd wait while they consult and do what they do, then they would fix it. But here we are 60 years later, and they're still consulting and saying, okay, after we consult, we'll fix it. And what's so troubling is First Nations women have historically had to carry the fight largely on our own. For decades, we've been told that we're asking too much, moving too fast, causing division, and we've been told just to keep waiting. But now there is a broad support for First Nations, from First Nations leaders and organizations, families, advocates, experts, international human rights bodies, all saying the same thing. It's enough. Change it. Do it now. We already know what needs to happen. The courts have said what needs to happen. The United Nations, Inter-America Commission, various other groups has said what needs to happen. This last one from what we're meeting about today has said, then it's been said over and over again. We already know what needs to happen. The courts have said it. I've been involved in every change on consulting since 1985. Canada's still trying to slow this down. When I made my application for status for myself and my son was 14. By the time it got through the court, my court case and the changes, my son was 44. It took 30 years. My own UN petition was ignored, and Jeremy's UN case was ignored. Recommendation after recommendation have been ignored. I hope this technical advice from the EMRIP won't be ignored as well. It is very sad that First Nations women have had to spend decades of our lives traveling to the United Nations and other bodies simply to try to get Canada to respect basic human rights. Canada's already claims to believe in and is committed to be upheld. And all the other groups in Canada have had the benefit of the charter and the human rights legislation and all of that. And we have been ignored, and there's specific legislation that doesn't allow us to use the human rights protections that other Canadians have. Canada signed on to these international declarations, endorsed these treaties. They are commitments Canada has made to protect human rights, and yet we are still here fighting the same discrimination generation after generation. The moment that Canada became a country, laws were created to separate us, reduce us, and eventually eliminate us through legislation and assimilation. And these laws have been targeted and disproportionately harm our women. Meanwhile, every year we hold Red Dress Day. Every year, the statistics around violence against Indigenous women and girls continue to rise. Every year, government says they are committed to reconciliation and ending violence against Indigenous women. But they could act right now and pass Bill S2 as amended and finally stop the legislating of extinction to our families and our communities. This should not have taken 60 years, and it should not take another 60 years. Canada does not get to say anymore that it does not know what the solution is. It does know. They've admitted it's discrimination, and they just said, well, just let us consult some more. There is only one solution that doesn't violate the Charter and international law, the one-parent rule, and an immediate end to the second generation cutoff. Now it needs to decide whether it's willing to finally do the right thing or continue standing on the wrong side of history. Thank you.
Thank you so much, Sharon. All of these points are so important. I wish we had even more time. But let's move on to Jeremy. Thank you very much, Jeremy, for being the reason why we're having this press conference today. Jeremy's a member of the Squamish Nation. He was the requester that led to this EMRIP technical advice to Canada, and he was also the successful petitioner to a submission at CEDA, the Committee for the Elimination of Discrimination Against Women. So go ahead, Jeremy.
Thank you, Pam. Thank you, Sharon. Okskwai, my name is Jeremy Matson. I am a Squamish Nation member, and I have direct ancestral connections to the Musqueam and Tsleil-Waututh and other Coast Salish communities. I'm also a registered person under the Indian Act of Canada. It is a privilege to be here today and to have the EMRP, or expert mechanism, answer my request for technical advice. For years, I've brought forward evidence to Canada, to the courts, to Parliament, to the United Nations, to the Inter-American Commission on Human Rights, showing that the second generation cutoff is designed to assimilate First Nations people out of existence. I am the successful litigant in UN Communication 682014, Matson versus Canada, from the UN Committee on the Elimination of Discrimination Against Women, commonly known as CEDAW. where CEDAW ruled that Canada was violating international human rights obligations through discrimination in the Indian Act. That decision was not symbolic. It carried legal and moral obligations. Canada was found in violation of Article 8 of the UN Declaration on the Rights of Indigenous Peoples in my case. The committee called on Canada to stop forced assimilation, fix the sex-based discrimination, remove the cutoff dates, remove the second generation cutoff. But instead of fully implementing that decision, Canada continued to defend and maintain the second generation cutoff. In fact, the UN Special Rapporteurs later raised concern that Canada was effectively imposing its own interpretation of its international obligations instead of complying with the findings against it. Now, once again, the United Nations has stepped in. The expert mechanism has issued technical advice reasserting the second generation cutoff is a form of forced assimilation that violates the UN Declaration on the Rights of Indigenous Peoples. This is not my opinion. It is just one UN, it's not just one UN body, it is a growing international consensus. CEDAW has spoken, the Human Rights Committee has spoken, the UN Special Rapporteurs have spoken, now the expert mechanism has spoken. Canada cannot continue to delay justice while generations of First Nations families continue to lose status, identity, rights, recognition under Canadian law. My family has lived with these impacts directly for 100 years. We have spent years navigating systems designed to erase us. This moment is an opportunity for Canada to finally stop fighting First Nations families in courts, stop delaying justice, stop defending discrimination that the world has already recognized as a human rights violation. Bill S-2 must pass with the Senate amendments intact. Canada says it supports reconciliation, international law, and human rights. Now it's time for them to finally prove it. Thank you.
Thank you so much, Jeremy. And thank you again for being the requester, because this has been very important technical advice. And last but not least, we have our powerhouse, Zoe Craig-Sparrow. She's a member of the Musqueam Band. She's the director of national advocacy for justice for girls, and she's a million other things helping to support us throughout all of this. Go ahead, Zoe.
Thank you, Pam. Aiswail and Zoe Craig-Sparrow, Tlitsnak Musqueam. Today, we are here because the United Nations has spoken again. And the question Canadians should be asking is, how many times does the UN need to tell Canada that the second generation cutoff is discriminatory, forced assimilation, and a violation of our rights before this government finally acts? EMRIP is now the second UN body in as many months to specifically urge Canada to pass Bill S-2 as amended by the Senate. In March, the UN Human Rights Committee called on Canada to eliminate the second generation cutoff and adopt Bill S-2 as amended. And this is on the heels of the UN Committee on the Elimination of Discrimination Against Women, CEDAW's 2024 calls for the repeal of the second generation cutoff and the elimination of remaining sex discrimination in the Indian Act. The government can no longer hide behind the argument that passing Bill S-2 as amended would somehow violate UNDRIP, or free, prior, and informed consent. EMRIP's technical advice makes the opposite clear, that the real violation of UNDRIP is continuing the forced assimilation of our people through the second generation cutoff. Canada also cannot continue hiding behind the Nicholas plaintiffs. The plaintiffs have been clear. They do not want to be used as an excuse to justify stripping out these amendments or delaying justice yet again. What we are seeing is consultation being weaponized against us. First Nations women, leaders, organizations, advocates, experts, and now international human rights bodies are all saying and have been clear for decades about what needs to happen. And yet Canada continues to say, we know you say you don't need more consultation on whether your rights should continue to be violated, but we know what's best for you, and we will continue to consult anyways. That's not reconciliation. That is continuing a pattern of genocide, assimilation, and broken promises. This issue cannot be separated from the genocide of missing and murdered Indigenous women and girls. The national inquiry clearly showed that stripping women and girls of their rights, status, identity, community, and belonging increases vulnerability to violence, displacement, poverty, isolation, and the MMIWG 2S+ crisis. CEDAW specifically recognized that the ongoing discrimination in the Indian Act is gendered in its impacts. EMRIP also recognized that the Indian Act is not gender neutral, that First Nations women and our descendants experience these harms differently and more severely. That is not an accident. That is a colonial system designed to erase us over time. And for me, this is deeply personal. I am a 6'2" status Indian. My status line ends with me. My children will not be able to inherit my home or exercise their rights to fish. In the eyes of the government, they will not be First Nations. Canada is legislating the disappearance of not just future generations of my family, but of all of our families. It is only a matter of time. We should not have to stand here and beg the government to stop forcibly assimilating us. If MPs strip these amendments out, they are knowingly leaving sex and race discrimination and forced assimilation in the Indian Act. They are actively participating in the legal erasure of our people and the violation of the Charter. They are complicit. Heiltsuk. Thank you all.
Thank you so much, Zoe. I think we all know people who have been directly impacted by this. Okay, let's turn it over to questions from the media. I'm going to go in the order that I see the little electronic hands. And if you could just identify yourself when you do ask a question. If there's time, we have about 20 minutes. If there's time, we can go around again, but it just depends on the number of questions. And so you can ask questions of any of us, and please direct your question to one of us, myself, Chief Slett, Sharon, Jeremy, or Zoe. And the first person I see is Palak from Parliament Today. Go ahead.
Hi, good afternoon. Just wanted to make sure you can hear me all right.
Yes.
Hi, this is probably, I think, for Ms. Slett, but others can speak to it as well. You said the government is weaponizing consultations or hiding behind that as an excuse to drag its feet. The minister, I believe, said last week that a standalone bill on this could come forth in the fall. But can you speak a little bit to this idea of weaponization, and is that sort of a tactic to buy time from your point of view?
It is. You've heard from many of the speakers here today as well that there's been decades of consultation, and we have resolutions from, UN bodies, parliamentary recommendations from parliamentary committees over time, and letters and witnesses that have come forward. The charter must be compliant, and the government must address redress for assimilation, and this is a requirement under UNDRIP. We can't have self-determination when there's these assimilation policies that are in place, and there's been a lot of consultation over the years, and the time to act is now. There's recommendations from the UN bodies, and so many people coming forward. Yeah, so I hope that answers your question. Thank you.
Thank you.
And, oh, sorry.
Sorry, yeah, may I have a follow-up?
Oh, go ahead.
Yeah, so I think this, again, may be for Ms. Slett. Just on a separate topic, on Monday, the head of the Trans Mountain Corporation and a federal official suggested that the government should consider hanging on to that project indefinitely and not divesting it. Is there opinion on this that you have, or maybe others have on this?
Yeah, I don't think I can comment on that right now, but thank you for the question.
And I think we'll just stay focused on the subject of this press release for now, if that's okay with everyone. So next I see Alessia from the Canadian Press. Go ahead.
Hi, first, Dr. Palmater, I need to know your plant care routine. Those are beautiful behind you. But my question is also for you, or Chief Slett. I'm wondering if the minister, Mandy Galmasti, has done any outreach to you to explain her positioning on why they want a standalone bill. Former NDP MP Lori Edloud was speaking to reporters last week and kind of said her mind was changed when she learned more about the government position. I'm wondering if the minister has done that same outreach to you too.
Go ahead, Chief Slett, if you want to speak to that, because she hasn't reached out to me directly or any of the groups that I'm with.
Yeah, thank you for the question. No, she hasn't reached out to me directly. I have participated in committee as a witness before the Senate committee when they were studying Bill S2, and just as early as last week in Ottawa to the INAN committee, also presenting as a witness as well in support of moving this bill forward as amended by the Senate committee, but I have not heard directly from the minister.
Go ahead, Zoe.
I just want to add, so the Indian Act Sex Discrimination Working Group has been requesting a meeting with the minister for, I believe, over a year now. We've tried really hard to engage with her and have a conversation about this, and those calls have gone unanswered. We've met with people from ISK, but not the minister herself.
Pam, I want to jump in here, Sharon McIvor. Just so that I had the first case that challenged the changes in 1985. I applied in 1985 for status. We got in July of 1989. We went through the internal process, and we were able to get into the courts, applied to the courts, and it took from July of 1989 to January of 2006 to actually get into the courts, because the Department of Justice, every time we wanted to set a court date down, they would go and tell the court that, oh, well, we're not ready yet. We've got 20,000 documents that we have for the consultation over the 1985 amendments, and we have to have time to review them. So the court would give them an adjournment. So it was in January of 2006. We're going from 1989 to 2006 before the court said enough, and we had to do some internal administrative processes to get to that point. And the moment that Madam Justice Ross said to the Department of Justice, you're going to court this year, the lawyer for justice disappeared. His only job was to delay getting into court. And then we got another justice lawyer that was actually going to handle the case. So their strategy was very clear. Let's not get this to court because we know we're going to lose. So yes, and this is what's been happening every time there's an amendment. And what they're doing in the House of Commons right now is what they've done all along. Oh, we're obliged to consult the Indians to see if they want to continue the discrimination in it. It's for me, because I've been involved with it about 5 or 6 times, as well as talking to absolutely every minister of Indian Affairs for the last 18 of them. And it's just, okay, yeah, we've got to consult, sorry, we'll get back to you about this.
Incredible delays.
I have a follow-up if that's okay.
Sure.
I'm going to be really oversimplifying the argument here, but Liberal MP Jaime Batiste has said along the lines of, okay, well, if there's no Indian Act changes right now, focus on band membership and control over your own membership list. I'm wondering what you guys make of that argument, and what the difference is between having Indian Act status and just being a member of the First Nation itself, and why that's important.
I think it's really important to understand that Indian status is an individual direct relationship with the federal government. The federal government has 100% control. First Nations already have the option under Section 10 to develop their own membership codes. The majority have not, primarily because they don't want to assume all of the legal liability for ongoing discrimination. They want to enact their codes when Canada finally fixes the Indian Act. And so they have the option to do that now, membership codes. Some bands do have membership codes. And then there's something called self-government citizenship, which is an enrollment process negotiated under self-government agreements. So by raising these issues, it's really trying to conflate and confuse people. But we're talking about Indian status. Bands have no control over that. It's only the federal government. It's federal legislation. They are constitutionally bound to have zero discrimination in it. So we've addressed that in our submissions and directly. Okay. Karen from APTN.
Hello. Yes, thank you for introducing me. So I guess this might be a question for the chief. I've got two, but the first one is, I mean, you're going to have somebody on the Liberal Party actually vote with C2 to keep it as it is. Are there any soft Liberals? Anybody that you think will move?
Thank you. Yeah, we're working really hard to reach out to the Liberal Party, to members of cabinet, MPs. We've been reaching out to all parties, and yes, certainly this is something that we know would be beneficial for all of us to be able to get this Bill S2 passed, and that's part of the work here today. Bringing forward the important work of the UN, the recommendations of the UN to Canada in particular, that they have an opportunity now to end that discrimination within the code, within the Indian Act. And yeah, we'll certainly carry on in that advocacy and hope to reach out to as many Liberal members as we can.
Okay. And then my second question is that Prime Minister Golmasti said that she was starting a consultative process. I've seen materials online. I guess it's a quick question for everybody. Has anybody yet been involved in the consultation process?
I do have a comment, to that. You cannot consult on a human rights issue or further delay human rights violations. And, this is something that this report speaks directly to. And, we're advocating that, that the federal government, continue onwards with, this bill as amended by the Senate committee, that it's not, we need to stop this. The consultation has been going on for decades, and you've heard some of the plaintiffs and the people that have spoken directly to the UN here today.
Yeah, I understand that, but I also just wanted to know if anybody's actually currently involved in a consultation process with the minister.
I am not. I've written letters to the minister, and as a Heiltsuk leader and member, and as part of the Indian Act Sex Discrimination Working Group, we've been working towards trying to meet with her, but we haven't had that meeting with her as of yet.
Okay. Thank you.
Zoe, did you want to add something?
Yeah, I'll just add to that the majority of the groups taking part in the collaborative process consultations who did testify to Senate were in support of these amendments and eliminating the second generation cutoff now. And Chief Barbara Cote, when she spoke representing 204 BC First Nations and who is participating in the collaborative process, she made it clear that in this process, the people involved have never been asked or told, do you want to stop this consultation and pass Bill S2 as amended? We're not given the choice. They're not given the choice. And so the majority of the groups who have been involved in the process, which is not very many, did testify to the Senate in support of this. And to be clear, again, to reiterate Chief Slett, you cannot consult on discrimination and you cannot consult on genocide. And whether you call it a consultation or a collaborative process, it's the same thing. And it's been happening since 1982, before the second generation cutoff was even put into effect.
Thank you.
Thank you so much. Okay, I see Marco from iPolitics, I think.
Hey, thanks for taking our questions. I'll field this one out to whoever would like to answer. But going back to what Ms. Idlot told us the other week, saying that one thing that changed her mind or had her come along to the government's position on S2 was this promise of standalone legislation. I just want to get a sense from you folks, if those amendments are removed from the bill, what confidence do you have that Minister Galmasti will bring forward separate legislation in a timely fashion to end the second generation cutoff?
Does anyone want to go before me? Okay. Here's the thing. Indian Affairs, Indigenous Services Canada has been making these promises every time there's an amendment to the Indian Act. Just wait, women, just wait. We'll address that next time around. And they don't. This question was actually put to the minister multiple times in the Senate committee. Oh, standalone legislation. So do you have a cabinet directive for that? Do you have a treasury board? Do you have anything in the works? Silence. Even on consultation. Well, it hasn't started yet. We're going to start in the fall. Oh, wait, we started back in 2023. Okay, well, how long is the consultation? Well, it's going to go on as long as individual First Nations need it. So no end date. And if that's the case, then you certainly can't have legislation in the fall. So none of this gives us any confidence that there will be standalone legislation. And if it was truly to get rid of sex discrimination and race discrimination and second generation cutoff, Senate's done that for them. Why are you waiting until the fall? Pass the Senate Bill S2 as amended.
Thank you.
No follow-up?
No, sorry, just one question.
Sure. I see Joy from CBC. Go ahead, Joy.
Hi, thanks so much for answering all of our questions. This one is for you, Ms. Palmater. Most of you have been witnesses before the INAN committee now, as well as the Senate. And many witnesses have brought up recently the idea of the one-parent rule, which some bands have brought up. As you mentioned, band membership is different from status. The minister has said in the past that, that's not an option for everyone, and has brought that up as a reason to, bring about more time. It was also brought up by many MPs in those meetings. I was just wondering on your thoughts about, a one-parent rule and, this reasoning as for maybe delays or an answer to, the amendments on S2 and concerns from First Nations.
And you did say that was for me? I couldn't hear the first part.
Yes.
Okay.
Yes.
Yeah. Okay. So here's the thing. We've been asked many times, how can you advocate a one size fits all for Indian status? Remember, it's not band membership, it's Indian status. And it's well, charter equality rights are one size fits all. Everyone gets to benefit from that. Human rights, the right not to be forcibly assimilated. Everyone gets that. So anything short of a one-parent rule for Indian status results in a definable legislative extinction date for status Indians and the majority of First Nations in this country. So we've said, and the Supreme Court of Canada has said in at least 8 Supreme Court of Canada cases, that you can't delay, you can't do incremental changes when it comes to charter equality rights, whether it's equality on the basis of sex, race, family status. So they don't have an option. It sounds very dramatic when you say one size fits all, but it's well, actually you're saying we all have charter rights separate from band membership. There's all different kinds of codes. For the minority of bands that do have codes, they use different processes, but of those different types of codes, the majority use a one parent rule because they too don't want to have no members in the future. But again, those are two separate things, Indian status and band membership. And I think it's just very important for the federal government to understand that, this duty to consult, you can't consult on whether to commit murder, to assault someone, to violate their charter rights, their you can't consult on that stuff. If your legislation has been found to be discriminatory, which it has many, many times, they lose every case. They have an obligation to immediately amend it. But here's what they're doing, saying, wait till the future. But they insulate themselves from liability in every time they amend the act, and they don't address all of the discrimination. They say, oh, and by the way, these women, they can't sue us. So this delay tactic is an unjust financial bonus for them. And we don't think that that's in good faith. That doesn't represent any of our human rights.
Thank you. And my second question is for Chief Slett, but I'll also open up if anyone wants to answer. So Parliament is meant to rise in a couple of weeks. I think they only have about 3 or 4 sitting weeks left before the summer. Are there concerns about this bill not passing before the summer break and the impact what nearly 3 months off before resuming debates might do to the status of this bill?
Mm-hmm. Yeah, I mean, we are certainly, I mean, this is why we're here today to bring further awareness to, we're not alone in our calls to action as a body here today, as First Nations women and communities. We've been on record here today and at the United Nations and in front of, the parliamentary committees that the consultation that they are embarking on is not appropriate. We have decades of that consultation, and we know that the time to act is now. And they have an opportunity now to act and to fix the mess that they made with the Indian Act and the registration. And we know that time frame is in front of us, and that's why we're here to raise that awareness and to continue to bring this forward.
I think Zoe wanted to add something, and then Sharon.
Okay.
Thank you. I just want to be clear that the Senate passed S2 in December. We are now in May. This lack of prioritization and these delay tactics are exactly why we have no faith that Minister Galmasti is going to prioritize standalone legislation when she's given no clear timeline, no clear explanation of how that's going to happen. So we're seeing the same patterns over and over and over again for decades and decades of lack of political will to prioritize ending the second generation cutoff. And again, the Nicholas plaintiffs have said, take as long as it takes. This is really important. But I find it really interesting that the minister, when she testified in APA, said, this is a priority. We need to get this done. Now the Nicholas deadline has come and passed. But either way, we're in this for the long haul. This is critical that this gets done. There was historic unanimous support in the Senate. And the Senate has said that if the House strips these amendments out, they will put them back in. This is important. This is critical. And we are talking about a violation of the Charter. So the Senate is clear too. They're not going to miss an opportunity to remedy a violation of the Charter, and neither should the House.
Sharon?
Okay, really quickly, for those of us that have been around for a long time, Pam, they did this with S3, remember? That we're getting into June, and they said we have to pass it, otherwise we're not going to be able to register any Indians after the deadline that the court set comes. And they ended up doing what they needed to do. They didn't send it back to the Senate, and they accepted the Senate's amendments, albeit they did delay on when those amendments that they didn't want came into effect. So, this isn't the first time around this.
No, around we go. Okay, so I think we have time for 2 more questions, and I see 2 more hands. So City News and APTN. Go ahead, City News. Are you there, City News?
Sorry, I was trying to find the unmute button. Okay. Thank you for taking this question. I understand this may be a difficult one, but for anyone who's willing, could somebody, speak to the human side of this, the difficulty of explaining to a child why they're not going to inherit status? Because even for adults, it can seem very incomprehensible. So if anyone is willing to add that story, that would be greatly appreciated.
Would you like to go first, Zoe? Because you're the cutoff.
Yeah, sure. So I am a 6'2" status Indian, and I am the cutoff. I am engaged to be married in October to a man that I love. He is not a status Indian, so my children will not have status. And this looms over my head every single day, like family questions of, what am I going to do? How are my children going to inherit my home on reserve? How are they going to be able to fish? Like, my fishing is so important to our culture and to our community and to my family. I grew up fishing on a fishing boat with my grandfather and my mom and now my little siblings. And my baby won't even be allowed to be on the boat with me while I fish. They're not going to be able to play soccer in our Indigenous soccer tournaments. I was just playing soccer with my mom and my sister this weekend, and you need a status card to play. They're going to be sitting on the sidelines of exercising their right to fish, of playing soccer with their cousins and their families, of being able to vote in our elections, of being able to access Jordan's Principle or healthcare or education support. And they're most importantly not going to be able to inherit a home on reserve in their community, in their territory. And that's unfathomable for me to understand. And I am prepared to fight for my whole life, like Sharon has, to make sure that doesn't happen. But I would really rather not. I would really rather be able to have a child and have them be born with the same rights that I'm born with, the same rights that all First Nations people are born with, regardless of what the government says, but we are owed them. And that's heartbreaking to think that that might not be the case when they're born. Chief Slett might have something to add.
Yeah, thank you for that really important question. My grandchildren live here in our Heiltsuk village, Bella Bella, and they are not entitled. They're not recognized as status Indians, and they are living here. They're going to grow up here, surrounded by their family and by their ancestral homelands, but will not be entitled to the same as their cousins and other family members. And that's the distinction that Pamela was making earlier around band membership and the legal entitlements under the Indian Act. And there are many children in our community that are not entitled. And there are many parents that don't know until they have their children and are trying to enroll them into the band and are told at that time that they're not entitled. So it's something that is very discriminatory and also very hurtful and causes harm, to our people.
I think this question was important because it does irreparable harm. You can never undo the harm. It would be more than just even financial compensation for programs and services. Like, my kids grew up without Indian status. They were always told that they were less Indian than their cousins, from the same ancestry. They never felt like they were included, despite the fact that I have a massive Mi'kmaq family. Some of them live on reserve, some of them live off. You never lose that. Am I enough? Am I Indian enough? Am I still Mi'kmaq? What does this all mean? And they're in their 30s now. They watch their entire lives me have to use all of my advocacy, all of my academic, all of my professional work just to try to get justice for them. And we got justice for them. They're registered. But now my baby son has grandbabies, and my grandbabies are not included. I am their migiju, I am their granny, and I am teaching them everything I possibly can. But there's going to come a limit, because the federal and provincial governments often use Indian status, not even band membership, but Indian status, to deny our ability to access Aboriginal and treaty rights that are ours, that existed long before there was an Indian Act. And I don't want my grandkids to grow up with the same sense of I'm not enough, and to be very confused about all of it that my kids did, when but for the discrimination, all of us would have been included the entire time. And that's why I'm thankful to people like Sharon McIvor and, the Deschanel case and Jeremy Matson and Jeanette Corbière-Laval and Mary Tuax Early and all of these women who just keep suing Canada and winning over and over and over again, because without them pushing, none of us would be included. And that's hard to believe. I wouldn't have a voice. I wouldn't be recognized to come and talk here. I'd be like, well, you're just a fake. You're not real if you're not a registered Indian. So it makes a huge difference. The human side of things. Okay, if there is no one else, I will go to Fraser and then he will have the last question. So it's got to be a good one, Fraser. Like, this has got to be the gold standard question. If he's there.
Yeah, I'm here. Wow, the pressure's really on. I'm just shaking. My colleague Karen is there, she can tell you. Yeah, and I know you're running out of time here, but I guess as it's come from all the witnesses that we've seen, that the government doesn't need to do more consultation, then aside the fact that's been mentioned here, that's a human rights issue anyway, so that's not something that you consult on. The government insists that it needs to keep consulting. What do you think their real goal is? Why they're so determined to do more consultation? What's the goal of this then?
Is that for someone in particular?
No, anyone can answer it. Yeah.
Sharon, Chief, Zoe, Jeremy, anybody want to answer that? If not, okay. They're trying to continue on with this disappearing Indian formula. That's what the second generation cutoff is, so that you can ensure that there's no Indians left in time. And when you start getting in trouble for that in the courts, then your biggest hope to eventually end Indians in the future is to ask bands to develop membership codes or to engage in consultations that say, yeah, we don't want these women and kids back. And they keep trying over and over and over again. But we have never had this big of a consensus. So all of the First Nation leaders, chiefs, and the First Nation organizations that represent a number of chiefs, the totality was the majority of First Nations in Canada saying, consultation, how about listening to our voice now? We're saying, end the second generation cutoff. That's what the spirit of consultation is. Not that you go through some meeting process. It's, here's our voices. Here's what we're telling you. The Senate's listening. We literally wrote the amendments for them. They said, look, it's not you tell us what you want. And now we have a situation where the minister is saying, I'm going to ignore all of the First Nations in Canada, but a handful, including the Assembly of First Nations, which passed a resolution saying get rid of second generation cutoff. And we're going to force you into consultations as a delay tactic so that we can just keep this going, save a whole bunch of money because A, we're not going to compensate these women, and B, less Indians over time. But then think about, where's the duty to consult on C5, the One Canadian Economy Act, or all of this other legislation that they're proposing that will just rip apart environmental protections? We were saying, First Nations were protesting, you need to consult with us. This affects our Aboriginal treaty rights. No, sorry, we went to court. There is no legal duty to consult on legislation. But when it comes to denying the rights of women, and it seems to always be the rights of First Nations women, whether it's murdered and missing, no action. Forced sterilization, no action. Kids in foster care, no action. Sex discrimination in the Indian Act, no action. They have no problem saying, no, we're going to consult until the cows come home. And that's not really consultation when you ignore the voices. That was the biggest consensus we've ever had on this issue. Go ahead, Zoe.
There's not much left to say. No, I just wanted to add that they are quite clearly doing this as a delay until either they run out of time or perhaps because they just don't want to remove the cutoff, or maybe the minister doesn't have the mandate from the prime minister to end the cutoff. But delay, delay, delay is all we're going to keep seeing. And it's no different than it's been for decades and decades and decades. So also, I want to add, if the government is really serious about upholding Indigenous rights, consultation is meant to be used when it infringes on rights, not restores them and undoes discrimination. And what the government can consult on and collaborate on is how to support communities once the second generation cutoff is removed from the Indian Act, how to support communities welcoming people home, how to support communities developing their different membership codes. The consultation should not be on removing the cutoff. It should be on what happens after it's gone and after Bill S2 passes as amended by the Senate.
Okay, thanks.
Okay, so that's 1 o'clock. We just issued our press release, and Zoe is in fact the contact. You can get in contact with any of us if you don't already have our information. If you have more questions or want to expand on any of these things, her contact information is at the very bottom of the press release. We posted links to EMRIP. And I just want to thank so many of the media for joining us. And Jeremy, once again, for making this request and having this technical advice given to Canada for everyone at UBCIC who works nonstop with the Indian Act Sex Discrimination Working Group, supporting us, even this press conference today. Thank you. We couldn't have done this without the UBCIC. So thank you to all of you, Chief Slett, Sharon, the grandmother to tens of thousands, Zoe and Jeremy, and everyone in the media. Thank you so much.